Tennessee is now in session.
Thank you, Mr. Hibner, and thank you to the attorneys and parties for participating today. As we've said throughout the past couple of months that we've been trying to do this is a work in progress, and we're learning more as we do it with each video conference, and we appreciate you agreeing to be, I won't say guinea pigs, but at least participants in a developing process might be a better way to put that. Want to, first of all, just touch on a few matters, and then I'll let Mr. Hibner call the case and we'll get started. Obviously, we have experienced practitioners here who've been to the court before. You know that each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time, but please do that after you introduce yourself, and please request that from the court. Our panel today is Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg, and we will be your panel for this case. Anything else we need to take up, Mr. Hibner, before we get started?
No, Your Honor.
All right, and I also want to thank Mr. Hibner and his staff. They have been doing the yeoman's work in making this process work. The AOC staff has been wonderful. The technological innovations that they've done and the technology people that have been involved in it have been just really wonderful, and we want to thank them as well. So, Mr. Hibner, if you would, please call the case.
City of Memphis versus John Pritchard.
All right, we may proceed.
Good afternoon. My name is John Cook. I'm here on behalf of the City of Memphis, and I would like to request 5 minutes for rebuttal. That's
all right. You may proceed.
Okay, we are here on the case of the City of Memphis versus John Pritchard. This case arises out of a parking ticket that was placed on Mr. Pritchard's vehicle while he was illegally parked in downtown Memphis. The parking ticket was placed on his vehicle by an employee of the Downtown Memphis Commission, or the DMC. The DMC is a district management corporation, which is a creature of statute. The statute is TCA section 7-84-519. What that statute does is it allows municipalities like the city to delegate municipal powers and services to a DMC that acts as the city's regulatory body in a particular geographic district. The municipal powers and services that can be delegated to a DMC include those related to public safety, security, regulation of vehicular traffic, and the elimination of problems related to traffic and parking within the district. Now, given such a broad—
where do you find that authority?
That authority, it's two places. It's in the statute, the Tennessee Code annotated section 7-84-501 et al. Or et sec. And then the ordinances mirror those powers as well, the local ordinances.
And are those powers defined?
Those particular ones are pretty broad. Those particular ones, don't get down to the minutia of what exactly it would mean to, regulate vehicular traffic or eliminate parking problems. But it's to be construed broadly. The Tennessee statute, says that these powers are to be construed broadly.
And this citation, I assume it was a citation that was issued. I'm not really sure what it was. In fact, what was it? Is that a traffic ticket? Is that what exactly is a parking ticket?
That's the question in this case. The city has maintained that it is a traffic citation, which has a definition under the ordinance. Mr. Pritchard has argued that it was a summons or it was a misdemeanor citation. Now, I don't want to presume too much, but it appears that on appeal, Mr. Pritchard has acknowledged that it is not a misdemeanor citation because there was not a criminal matter. And I'm sure Mr. Wells can clarify that. But it appears that, you know, the question becomes, was it a citation or was it a summons? The city has maintained that it was a mere citation. And we think this is consistent with the record. Both the ordinance and the record, the face of the ticket, show that a violator has 15 days to pay the ticket. And if he fails to pay, then the matter is put on the docket for the city court and a formal action begins. This is in contrast to a summons where a formal action has actually already begun. And the summons is a notice of the formal action. Also, a summons, unlike a citation, must be either personally delivered or mailed to the violator. Here, the ticket was not personally delivered. It was not mailed. It was simply placed on the vehicle. Indeed, there's no place for a name or an address on the parking ticket, as there would be with a summons. So we believe that the record at the very least creates a fact question as to whether this was a citation, and a traffic citation we maintain is not subject to any of the limitations in the ordinance that Mr. Pritchard relies on. And if I go, you know, the city also maintains that even if it were a summons, that the particular summons was validly obtained by the DMC employee. If you look at the ordinance in question, and it's City of Memphis Municipal Code Section 2-84-13, it's reproduced on page 13 of the city's brief.
Was the citation signed by anyone?
The citation was not signed by the violator, and let me.
Was it signed by the person issuing it?
There appears to be the name Turnage on the citation, which I believe was the DMC employee.
And as I understand it, the appellee is asserting that there was no authority given to this person to issue this citation. Is that correct?
That's what I would assume.
And if we were to look for that authority, where would we find that?
I think we would find the authority in the ordinance, combined with a reading of the statute. As I mentioned before, the powers that may be delegated to the DMC concern security, public safety, traffic, elimination of problems with parking. And then the particular ordinance that's focused on is, like I said, Municipal Code Section 2-84-13. And Mr. Pritchard, in the argument below.
And what specific authority is granted in the ordinance?
The ordinance.
The ordinance.
I'm sorry, Your Honor. Well, the ordinance says enforcement of any power or authority granted to the commission shall be delegated by the commission to any employee of the commission staff. So it would include, the city maintains, those broad powers that go to the commission would include.
And so is there another document you're relying upon, or are you just relying upon that language?
I'm relying on the Tennessee statute.
Well, I understand that, but I'm talking about the authority that the commission, whatever authority the commission has. How does the commission delegate it to an individual to go do whatever it is that that individual is supposed to do?
Well, I mean, there's in the record, there's testimony from the director of security for the commission. And she describes the process that has been going on for quite some time, where
I thought this was a summary judgment hearing.
It is.
Okay, so what are undisputed facts are relied upon or were relied upon by the court to determine that this authority was not there. And what are you saying that the court missed?
Okay, well, I believe the court looked solely at the ordinance, and in fact, only part of the ordinance to conclude as a matter of law. The employee didn't have the authority, and it was partly based on, I think, the court's assumption that this was a summons, or the court even referred to a citation in lieu of arrest. The court, we maintain, made an error of law in the sense that it didn't consider the broader powers. But with regard to the factual question, I think the testimony from the director of security for the DMC described the process whereby the DMC employees receive ticket books from the municipal court. And there's a reference to the DMC in the ordinance to the DMC employees obtaining summons through the municipal court. And as the testimony
Is that a different procedure though? Aren't we talking about a different procedure there?
Well, the city would maintain that it's a citation and not a summons. But if it is a summons, the only procedure referenced in the ordinance is permissive. It says that a DMC employee may obtain a summons through the city municipal court. And the testimony shows that the parking tickets were obtained from the city court clerk. I believe that Mr. Pritchard maintained below that some sort of, in addition to obtaining the summons from the court, some sort of judicial finding would be required. But there's no reference in the ordinance to a requirement for judicial finding. It just references just says who may obtain the summons through the city municipal court. And as I said, the testimony of the director of security shows that the parking tickets were obtained, in fact, from the city municipal court.
Okay, I know your time's out, but I'd like to ask you one more question, and that's this. You keep referencing the testimony from the director of security. Was that presented to the court? And if so, how was that presented?
It was presented in response to the initial summary judgment motion. It was the affidavit of, I believe her name is Deborah Streeter. And so it was not part of the motion to alter. It was included within the initial motion or response to the initial motion.
Okay, thank you. You've got your rebuttal time.
Thank you, Your Honor.
We'll hear from the appellee.
Thank you, Your Honor. Murray Wells here, may it please the court, with the Shelby County Bar. I'm here with Attorney Johnny Pritchard, who is, of course, the appellant, and also an attorney listed on the pleadings here. And I appreciate the court's time and working with us in these strange times. I think the court is kind of focused in on what we believe to be the issues here. One, that there is no authority for the DMC, the Downtown Memphis Commission, to issue these citations, these traffic tickets, as they call them. And the only thing they do rely on is 28413 of the city code. I think a good place to start is to look at the ticket itself. And when the court looks at the ticket and you read the language of the ticket, it couldn't be any clearer that you were being summoned to court. You have two different choices you can make. What you can do is you can pay a fine or appear in court. And it gives you an exact date, which was July 26th of 2016 in Division 2 at 1:30. And then if you go down and you read the ticket even further, it says that if you don't pay 4 days before and you don't appear in court, negative actions can be taken against you, meaning a default. The only way that could happen is by summons. The only way that the court would have the authority or jurisdiction to take a default judgment against someone is if that person had been summoned to court. So when we read the ticket, we can see that it is a summons. Even when you go to the definitions of
let me ask the question, please. assume you do neither. Assume you don't show up and you don't pay the ticket. What can happen? What are the consequences?
Well, that answer is in the ticket itself, of course, which is part of the record. Failure to pay or appear on court on the date above may result in a judgment for the amounts and penalties listed. Mail a check or money order to the self-addressed envelope, pay in person, make an e-payment, or pay online as instructed below. And then they also, not only do they give you the fines, judgments and docketed tickets may include all of the following fees and penalties: a $50 fine, $135 court cost, $1 state tax, $20 late fee 50 days after issuance, plus an additional $40 late fee at 90 days after issuance, and vehicle immobilization or impoundment. So all of those things can happen if you don't show up. Your car can be impounded. It can cost you hundreds of dollars in fines. So there's certainly there's a large detriment if you rely on this, and it's not a citation.
Well, I'm just trying to figure out whether we're talking about something civil, something criminal, something penal.
Well, I think it is definitionally, it is a traffic summons and it is a civil action. The fines, I think, would be civil. I don't think that there would be a now, arguably, the impoundment of a car could be something different. Could be detrimental governmental action, but
that's what I was thinking as well.
So that's certainly out there. And I want to talk about the distinctions because I think we're sort of parsing hairs between a citation and a summons. It's pretty clear that this is not a traffic citation because what the citation, if no one appears to pay such traffic citation by the end of the 15-day period, then a summons shall be issued. So in other words, if this was a citation and you didn't show up for court, then they would issue a summons. That's not what happens in this case. In this case, Mr. Pritchard, if he does not show up, they're not going to issue a summons. They're going to take a default judgment against him. And so this is clearly not a citation. Moving forward, that this is a summons, indeed, a traffic summons, the question becomes, where did the authority for the Downtown Commission come from? And there is no authority. The authority that the city relies on comes from as they said, 284.13, which is clear that they're limited in their authority. Delegation to the commission to any employee of the commission staff who may obtain summons through the city municipal court, and also to any city police officer who may issue summons, which is what happened here, or misdemeanor citation, or effective physical arrest for violations. So the limitation on the employee of the Downtown Memphis Commission is to go get summons issued. I believe I understand the argument by the city to say that getting a ticket book from a court clerk is somehow going to the court and getting issuance of a summons. And those are not the same thing. The issuance of a summons is an action by the court. They simply got forms from a court clerk's office. So to say that somehow anybody can go down and grab a ticket book and then that has caused them to go down to the court and get an issuance of a summons, I would submit just sort of defies logic. And I'll give you an example of how this works in the real world. What this is really about, from our understanding, is that this ordinance, let's say you've got your dumpster in the alley and you've been having a lot of shrimp boils and that shrimp gets pretty ripe. The Downtown Commission can come down and say, hey, listen, you need to get these nasty shrimp out of here because you're stinking up the alley and you're impeding business. You need to clean your dumpster out. Person says, okay, thank you, and refuses. More complaints. They refuse to take the bad shrimp out of the dumpster. At that point, the employee would go to the court and say, listen, we've covered this issue with them. The stinky shrimp are still in the dumpster. Will you issue a summons so they can come down? And it advises court why they're committing this odoriferous trespass on the city of Memphis. So that's the practical effect of what this is supposed to do. is not supposed to grant wide authority to issue tickets in any circumstances that require someone to appear at court or have a detrimental effect to their property and to their person. So I think that's the gravamen of the argument. As a note, I would say that this thing took a long time, and the court really pleaded for the city of Memphis to provide information, and some 16 or 15 months went by, and there is no authority that was provided. And so you can tell that the motion was filed in December of 2016, and the order didn't come down until May of 2017. And through that whole period, there was no response by the city. Only then, after the court ruled, and I'd say probably reluctantly, then the city comes back and says, well, you've missed some evidence. But there is no evidence. And today, still, there is no evidence. So in terms of the motion to reconsider, the judge actually did, in its order denying the motion, on the motion to alter or amend the order granting summary judgment, the court did consider whatever else they gave him. As in footnote 1 of that order, the court says the court did analyze City of Memphis Municipal Code 1184, which isn't argued here today, I don't believe. See the court's corrected order, page 8, where this court analyzed the difference between summons and traffic citations. This was a thoughtful, drawn-out process, and there was simply no contradictory ordinance or code in either Tennessee state law or the city of Memphis that grants the authority to haul somebody into court in the manner that they did if they're not specially delegated that authority. I'll say one more point, and I'll entertain any questions the court may have, is that there are occasions where the city charter does grant such authority. And so this is not a unique animal. The fire department has been granted, especially by charter, the ability to haul somebody into court. They just simply didn't do that here. It's just not there. And so at the end of the day, we're asking the court to uphold the decision of the trial court.
Does the record contain any information about the training that these people who were issuing these citations, what their status was? Were they just employees of the commission, or did they have some kind of special training or knowledge or anything like that?
No, the closest I can get, Your Honor, is under the affidavit of Deborah Streeter, which was provided in response to the motion for summary judgment, and just says certain employees of the DMC are designated to write tickets within the defined areas. Those employees, including S. Turnage, obtain ticket books from the city court. And that's all. It's silent as to whether or not there's any training. Even if you fill out the book, we don't know. They never presented that to us.
Okay. Thank you.
Thank you.
Mr. Any
Pritchard,
additional questions for Mr.
Can I
Webb?
interject, please?
No, I appreciate it. You're represented by counsel, though.
Okay.
Thank you.
Even though you are a lawyer, I think that probably we would be best suited if counsel did the argument.
No argument.
Thank you, Judge.
All right. We will hear the rebuttal.
Thank you, Your Honor. Just a couple of quick points. Of course, the city maintains, even if this were a summons, it was validly obtained from the municipal court. But there's more indication in the record that it was not, in fact, a summons. As I mentioned before, a summons must be personally delivered or mailed to the violator. That's not what occurred. There's actually no place for the violator's name or address on the ticket. Additionally, if you look at the city court docket, which was included as part of the record, it shows that the ticket date was June 19th, I believe. And then on July 5th, because Mr. Pritchard had not paid the ticket, which is approximately 16 days after the ticket date, a notice of hearing, which we maintain is the summons, was sent by the city court. And the hearing was set for August 16th, 2016. And so that's consistent with the citation where if the violator does not pay within 15 days, then it's placed on the docket, then there's notice of the formal court proceeding, and Mr. Pritchard obviously received notice of that, and the hearing on August 16th of 2016. One final point, Your Honor, I think that the affidavit, as Mr. Wells mentioned, shows that the DMC has in fact designated certain employees, has in fact delegated their authority with regard to parking issues. And that's what took place here.
Well, I don't see any further questions, so we certainly appreciate your argument. We appreciate you participating in this process. And I hope, I thank you, first of all, for allowing the wheels of justice to continue to turn by utilizing this process. We will attempt to get you an opinion as quickly as possible in this case. And again, thank you for the participation. Mr. Hibner?
This
Thank you,
court is
Judge.
now in recess until 2 p.m.
Thank you.
Thank you.
And we're out.